California Lawyers for the Arts is a statewide nonprofit founded in 1974 serving artists and arts organizations. We currently have offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego. We offer memberships with benefits such as workshop discounts and archive content. So please go to our website, calawyersforthearts.org, for more information.
I'd like to introduce our speaker, Mark Leonard. He's been a longtime friend and supporter of California Lawyers for the Arts. He is on our advisory committee. He is the general counsel for Jelly Belly Candy Company. He's responsible for all company litigation and all legal matters regarding their intellectual property, e-commerce, outbound licensing, marketing, distributors, etc. I thank him very much for being here this evening. As a nonprofit, our speakers donate their time to us on an in-kind basis, so we very much appreciate his time and expertise. And I'm going to turn it over to Mr. Leonard.
Thank you, Lisa. Happy to be here again. Thank you, everybody who's listening and or watching. I apologize, I don't have video capability at home. So what I'd like to cover tonight is common trademark issues that every client faces. So for those of you who are attorneys, if you have clients in business, they are going to face these issues. If instead you're a business owner, even an independent artist, these are all things to take in consideration as you operate your trade. So what is a trademark? It can be words, obviously, phrases like just do it, symbols like the Nike swoosh, even colors. There is I think one of the early ones to successfully register a color in connection with their product was the Owens Corning Company for pink residential and commercial insulation. So if you're ever wondering why you go to a hardware store and only one brand's insulation is pink, that's why. It's a registered trademark of the Owens Corning Company. Product shape and packaging can also be registered potentially. The most classic example is the shape of the Coca-Cola bottle, but also the Toblerone bar, that triangular pyramid shape, is a registered mark in some countries, as well as distinctive packaging. The overall look of the packaging can be registered, and even sounds. The NBC chimes, the sounds you hear when you see the NBC peacock at the beginning of a show is a registered mark. There's a number of other ones. So that's the first part. It's one of those things. And the second part is what makes it a trademark, meaning that word, phrase, shape, color, whatever it is used in connection with goods or services. And what that means, it is sold in commerce. So you have a business name. Maybe you invest with a graphic designer in a very catching, striking logo. You don't have a trademark yet until you have used that mark in connection with the good or service that you're selling. So let's say it's an art supply store and you have a very clever name, you have a very clever logo. You don't have a trademark until you have a customer, until you make a sale in your art supply store. And that's what really distinguishes trademark from other types of intellectual property protection. Patent, which I won't get into, deals with particular designs or formulas. Trade secret is something else. You protect that by keeping it secret. There's no other requirement to it. Just with patent, once you have your patent, that's it. The biggest overlap though is with copyright, because there are certain designs or symbols or characters is where you see it a lot, where that character, Mickey Mouse is a great example, or in my own backyard, Mr. Jelly Belly, can be registered as a trademark when it's sold in connection with a good or service. With copyright, you could have the same image protected under copyright, and there's none of this requirement that it's used in connection with a good or service. The advantage of this additional use requirement, however, it means there's basically no expiration date to your trademark. If you are continuing to use that mark in connection with your goods or services, there's no time limit like there is with copyright or patent. So that's one advantage of trademark. However, not all marks are protectable, and that's an important consideration, especially for attorneys. If you're advising your clients, they're coming to you with potential names to register. Here are some things to steer away from. And this is the continuum of trademark protection. We're starting at the bottom, which is generic. Ironically, these were all trademarks at one point: thermos, escalator, and aspirin. But they became so popular that the consuming public began to refer to all classes of product, regardless of the manufacturer, by the trademark. So they were referring to insulated bottles, not just from the thermos company, but from other companies as thermos. And so It's ironic that once your product can be too popular, or your trademark can be too popular, and you end up losing all rights in it. Question came in, can you trademark something if you are pre-revenue? The answer federally is yes. And I'm going to get into this a little bit later, so we'll get into the details of that. So when I talked about how a mark can become generic, the consuming public associates all classes of product in a particular class from different manufacturers with the same name. That is the purpose of trademarks. The purpose of trademarks is to serve as a source identifier for the consuming public so that they become acquainted with your company's trademark, the products or services that are associated with it, and that helps to differentiate you from your competitors. And that's the whole point of trademarks, is as a source identifier. So obviously with genericism, they've completely ceased to function as a source identifier because everybody's product is, the consuming public refers to as under a particular trademark. There's no differentiation. So next up the continuum is descriptive marks. These marks immediately convey the nature, ingredients, quality, characteristics, or function or feature of the, or use of the specified goods or services. So here's some examples. Cran apple for a cranberry apple juice blend. So the reason why descriptive marks aren't protectable, in addition to not being very distinctive, you are taking away the ability for your competitor to offer a competing product and calling it the same thing. And I mean by calling it the same thing, not under the same trademark, but by accurately advertising it. So you wouldn't be able to register cran apple or have an enforceable trademark for cran apple for just a cranberry apple juice blend, because a competing juice company also should be permitted to offer a cranberry apple juice blend. So you have to come up with something else to distinguish that, and that's what we're going to get into a little bit later. Trademarks can also be geographically descriptive. Apple Valley juice, for example. If it was apple juice from Apple Valley, and you've probably got, if you're in an apple area like Apple Hill, you're going to have many different producers in that area that all want to be able to say that their juice comes from Apple Valley as well. Surnames, again, because there's obviously a number of surnames out there, and to be able to register one as a trademark and accepted under very specific circumstances, you're not permitted to do, because you're taking that surname away from other people who legitimately want to be able to use their name in connection with their company name and their mark. So it's a somewhat complicated and subjective area of trademark law as to whether the only significance of the mark is the surname. So if you're going through and you're an attorney, you're doing trademark searches and you're seeing some of these surnames, oftentimes there are other elements to the mark. You know, Smith's Art Supplies may not be distinctive enough, but if there are some other elements to the mark in addition to the surname, because the restriction is that it has to be primarily perceived by the consuming public as a surname. Deceptive matter is not registrable. One example was the mark, somebody sought to register the mark soft hide. And the thought was that, well, people are going to associate hide with leather, and this item is not made of leather, so you're being deceptive. Another way you can be deceptive or misdescriptive, let's say you are, making wine in New York and you want to use Napa in connection with it for whatever reason. Well, that's going to be deceptive because consumers are going to assume that the use of the term Napa comes from the Napa Valley region of California. That also, for those of you who may be in the wine world, there's a number of geographical restrictions on appellations where you're not permitted to use the name of that area unless your wine actually comes from that region. Scandalous or immoral matter. This is actually a little out of date because the Supreme Court has subsequently struck down these restrictions, preventing, this is an argument that the U.S. Patent and Trademark Office would prevent the registration of certain marks because they were scandalous or morose. Expletive terms, racially insensitive terms like Washington Redskins. However, in 2 cases over the last couple of years, the Supreme Court has struck that down on First Amendment grounds. A band called the Slants was the first case, made up of Asian Americans, and they chose to name to kind of poke fun at that racial epithet. So the whole point of it wasn't that they were in fact racist, they were actually trying to poke fun at it. And that case went all the way up to the Supreme Court, and the Supreme Court agreed with the band that in fact that is a registrable mark. Laudatory terms are also not registrable often. The best pizza, the ultimate bike rack, because again, they don't serve any distinguishing features. You know, you shouldn't be permitted to be the only one to be able to use the mark the best pizza. So that's why laudatory terms are not protectable. There are also a smaller class of marks that have actually received statutory protection, meaning that there are federal laws that protect the Olympics rings, the American Red Cross, there's a few others that no one else is permitted to use or anything similar to them to keep them distinguishing. We have a question on, would you trademark a character's name image when used in multiple lines of a children's book, the Harry Potter series, consumer product licensing, etc.? We're going to get into that in a little bit. Probably not be able to do it if it was just a character name in a book, but if it is used as a title or in the title, as the Harry Potter series did, or as you point out, in consumer product and licensing, and we're just going to talk about it a little bit later. Can you use the brand name that is already dead and no longer exists? There's been some really interesting cases in this area over the last several years with some defunct brands and then people coming along and trying to resurrect them in different ways. I think one was Pan Am in connection with t-shirts. In MySpace, companies that have discontinued a particular line of candy. Some people try to bring that back using the old one. And for the most part, the answer is yes. We're going to get into that a little bit later when we start talking about abandonment and what it actually takes to lose your trademark rights. But that's another great question. So some other marks that are not protectable. And I've never really understood the logic behind this, but the Patent and Trademark Office does not allow you to register the title of a single book, album. I really dated myself by putting CD in here, or even probably the reference to album, or movie title, and where it becomes registrable if there's more than one. So if it's a series, then that's fine. So once the second book comes out and you're using the same title, the second movie, etc., now it is registrable in connection with the entertainment services or the actual movie. And the second point here, which gets into the earlier question we have, you can register it for ancillary goods and licensed products. So when the first Harry Potter book came out, Harry Potter wasn't registrable in connection with books. However, it was registrable in connection with all the other associated products that came from that: toys, apparel, video games, whatever. So that's the way a lot of entertainment companies try to protect their names of their entertainment properties. Maybe they're not sure if it's going to be a series. Obviously, it's hard to tell sometimes before the movie's launched. And so they go out and they do a lot of product licensing to help protect that. And of course, so once you have these very famous series, Star Wars, Harry Potter, the 4 Dummies series, those were all registrable in connection with alternatively books or movies when the second book or movie in the series came out. So what marks are protectable? Subjective marks. These are marks that convey something about the product, but it's not immediately clear to the consumer exactly what it is. And if that sounds like a subjective judgment, it very often is. It can be very difficult, especially when I was in private practice, for a client to come along and I say, oh, okay, I think this is a suggestive mark. And we file for it. And then the USPTO comes back and says, no, this is descriptive. And it's like, and you're going to try to argue it. So there's a lot of gray area in this area of law. So apple a day for vitamins is an example. Apple a day keeps the doctor away, from the old saying. It conveys there's some health benefits to this product, and if it's for vitamins, so they're making a connection, but it doesn't immediately convey something about the vitamins. If apple was a primary ingredient in the vitamin, you might have other issues with it being more descriptive. But if it was just like an apple flavored vitamin, probably not an issue. What else? Arbitrary. This is a mark that is it's a name, it's a word in the English language, or any language, frankly. But we're talking about the US here primarily, so I'll stick with English. It is an English word, but it's used in connection with something apart from its normal definition. So Apple for computers, for example. And then the most powerful in the terms of trademark strength is what's called a fanciful mark, and that's a made-up word. Xerox, you're seeing a lot in the tech space over the last several years that, companies are just saying, well, I'm not going to bother with trying to figure this out and go through all this trademark searching and everything. I'm just going to come up with my own name. So that can be very, very strong if, in fact, you can actually build up that association with your customers. Choosing a mark. How will it be pronounced? It's important because if you think you have a certain pronunciation of your mark and it's capable of different pronunciations, the way that you intend it may not carry the day. So for example, if it's, Apple with a misspelling or another term with a misspelling, it's going to be, if it's really similar to Apple, for example, 3 P's instead of 2, that's not going to be sufficient to distinguish itself from all of the Apple marks that are out there. This next point is less important than it used to be, but it used to be a consideration. Where will it appear in a directory, particularly a telephone directory? People often chose a lot of marks beginning with the letter A simply because it would appear in that section of the phone book higher than in, if it was a letter further down in the alphabet. Obviously less of a concern now. Now we're more concerned about, Google search results. Where am I going to appear that? And that's a whole another topic in terms of how you appear higher in those directories. A good consideration now currently, though, is can you get the domain? And that's becoming an important question because there's so many domains already registered, even by people not even using them. It can be difficult. And so that's definitely a consideration. Not so much a consideration here in the US, but these 3 examples give you some examples of companies who didn't think about how their mark might be translated. Reebok came out with a women's sneaker called Incubus. And Incubus is in fact a demon who impregnates women in their sleep. Probably not the best connotation for a woman's footwear. In Chevy in Mexico, somebody should have checked to see that Nova in Spanish means it doesn't go. Again, not a great branding for a car. But one of my favorites is in China, and you see this a lot with unintended translations, especially in China. Come alive with the Pepsi generation, a very old tagline of theirs, literally translated to Pepsi brings your ancestors back from the grave. So definitely a consideration if you're planning on doing anything overseas. Excellent question. The company name I'm using is similar to a construction company I found online, completely different industry. When you're searching, what are you searching for? Because as this questioner just raised the issue is not whether you're using the same mark. There's a second question. Is it the same mark in connection with a related good or service? So Acme in connection with art supplies versus Acme in connection with auto parts. So those 2 Acme marks can coexist because consumers are not going to be confused as to the source. And again, the whole point of trademarks is as a source identifier. And so trademark conflicts arise when there is what we call a likelihood of confusion. And I'll discuss this a little bit more. But that, the example I gave between auto parts and art supplies is a pretty easy one. But conflicts may not be readily apparent because the Patent and Trademark Office has determined that there are some products and services that are related. You see this a lot with restaurants because restaurants usually serve beer and wine. A brewer or a winery seeking to register a particular name that is already being used by a restaurant, the Patent and Trademark Office concludes that those are related goods and services, and so consumers may in fact be likely to be confused. And that is the whole point of trademark law, is we don't want consumers confused. That's why you have to follow all these rules and make sure you choose marks that are different from your competitors so that you're not confusing people as to the source of the product or service. So oftentimes when a particular, I remember one time I represented a organic fertilizer company and they wanted to come out with a new product. And there was a gardening blog using a similar name that had registered that name. And the USPTO had determined that that was a conflict because although obviously a fertilizer product, you're not going to necessarily confuse it. You're never going to see the blog when you go to the gardening store to buy the fertilizer, and when you go to the bloggers page, you're not going to see my client's product. But because they're both gardening related, that the PTO found that there was a conflict there. This next bullet is something that really frustrated my clients when they came to me. They would get their company name either incorporated or as a limited liability company, limited liability partnership, and assumed that because the Secretary of State had approved it, that therefore there was no conflict. That was, well, yeah, the state has approved the use of my name. How could it possibly in conflict with somebody else's? The Secretary of State is not doing a trademark search when they approve your name. They have their own internal criteria for whether or not a name might be too similar in certain ways, and it's different criteria than the U.S. Patent and Trademark Office uses on whether a company name a new company name conflicts with an existing company that's already registered. So that is not conclusive. Similarly, had a lot of problems with clients upset that they will I registered the domain name and now I have the cease and desist letter from this trademark owner saying I can't use it. Well, why did GoDaddy sell this to me if I can't use it? And for the exact same reason, GoDaddy or any registrar is not doing a trademark search when they are selling you a domain. Another thing that comes up often in the domain space is, are you actually, if your mark is in your domain name, are you actually acquiring trademark rights through that? And the answer is usually no, because the U.S. Patent and Trademark Office has determined that the domain name functions almost like a telephone number or a physical address. It's not distinctive. It's not necessarily associating that name with your product or service. You would need to have more prominent use of that mark on your website. So it's not that you can't have it in the website, you just can't rely it solely on it being in the domain. You can't rely it solely being in the domain name to be acquiring trademark rights. So Acme, artsupply.com, probably not going to get any trademark rights in that. But on prominently displaying Acme Art Supply on the web page itself and actually selling art supplies is going to give you those trademark rights. So how do we assess potential conflicts? And as I mentioned, the primary one is the likelihood of confusion. It's not actual confusion. Although that is one factor, there's about a 12-factor test that you look into when you're assessing this from a legal standpoint. I won't get into all of it, but the main things to be thinking about, especially if you're a layperson picking a name, you're an artist, coming up with a name for your gallery, is that it is a similar mark. And that, again, is sight, sound, and meaning. So like my example previously of misspelling apple with 3 Ps, if you find a conflict out there and you decide to spell it a little bit differently, but if it has the same sound or if it has the same meaning, you could pick a completely different word, but it has a similar meaning or a particular phrase, that's still going to be a conflict if, and this is what we were talking about earlier, if it's used on related goods or services. So that was the example I gave with my client, the organic fertilizer company. Is it okay to use a picture of a great-grandfather from 1900 as a logo? This gets into some very complicated areas of law. When you're talking about pictures, you're talking about copyrights. And when you're talking about copyrights, oftentimes the copyright is owned by the photographer, not necessarily the subject, or even if the photograph, maybe in this case, has obviously been handed down through the generations, it probably is impossible to know. And you start getting into a very complicated analysis of when was the picture taken? If you can absolutely determine when it was taken, you can go back and determine at what point could it have been copyrighted if it was in fact registered at that time. And when I say this is complicated is because throughout the years, the Congress has changed the terms of copyrights. So finding out whether or not a particular image or photo is still potentially under copyright protection, you have to go through and try to figure out, well, when was the photo taken? Could it potentially still be under copyright? The other complicated part of your question, when you start talking about images of individuals, living or dead, and then you get into, well, if they're living, do you have their consent to use the image? In some cases, you can document that and it's fine. In other cases, like here, obviously, you can't obtain consent, but in many states, you don't have a post-mortem rights in your image. And it gets even more complicated when you start getting into some of deceased celebrities and uses of their image. Depending on where the celebrity died, when they died, whether or not that state grants post-mortem right or publicity rights, then it's a mess. For example, the Einstein Foundation very aggressively pursues uses of Albert Einstein's image. The Martin Luther King Foundation is also very aggressive on that front. And then there's other celebrities because of where they died. I believe that the New York court determined that Marilyn Monroe that her estate did not have rights in her name or image based on where she was when she deceased. So it can be a little complicated. Next question, how does one do a trademark search for a logo? That is a very good question. The Patent and Trademark Office actually breaks down a logo or an image into discrete elements. So for example, the Mr. Jelly Belly logo is broken down into a bean, into what they call it I forget the exact name, but it's like a cartoon character. So they're going to deconstruct the image into all of these different elements that comprise the image And each of those elements is assigned a design code. And so it can be pretty complicated to do it yourself if you're an attorney, which is why many attorneys use outside search firms, that are professionals at this. And so you're going to get a search report back that shows all of the images. And again, those images, what you're seeing back in that search report is based on these design codes that the USPTO is using. Another question. So if a graphic designer creates a logo, is it owned by the designer or the business who's hired the designer? We're going to get into ownership issues a little bit differently, but it is a fantastic question, especially in this space, since this comes up a lot between graphic designers and the people that have contracted with them. So another type of conflict, aside from likelihood of confusion, is called dilution, and it is separate. And in this area, it's not the consumer isn't confused about the source. They can determine, they've made the distinction. Okay, I realize this isn't coming from the same company, but where it comes into play is where the first user, the prior user, has developed a lot of fame and notoriety in their mark, and other people then try to trade off it. So blurring is where the association arises because of the similarity, because of the offended mark and the famous mark that impairs the mark's distinctiveness. It became famous for a reason. And so if others are trading off it, that diminishes or dilutes the fame of that mark. So you see a lot of this with McDonald's, restaurants trying to use some variation of the golden arches or something else. Starbucks also faces a lot of this. And the next type of dilution is tarnishment. And that's where you're not just impairing the famous mark's distinctiveness, you're actually harming the mark's reputation by associating it with something that the mark owner doesn't want to be associated with. A good case on this was when Victoria's Secret went after I'll call it an adult novelty shop called Victor's Little Secret. It was one little retail location. They thought they were being clever. Cleverness aside, they were clearly making an association with the much more famous mark Victoria's Secret. Victoria's Secret didn't want to be associated with adult novelties, and ultimately won. Another one, and we don't have a decision on this because it was actually settled before it came to a decision, was the North Face brand of outdoor equipment and clothing. Actually, I think it was a college student who thought it would be funny to kind of poke fun at North Face by coming up with a South Butt mark. And the logo looked very similar, but it was, South Butt instead of North Face. And it was very clever, but ultimately, North Face was not too amused. But yeah, like I said, ultimately that case settled. So what are some trademark search resources? Well, the USPTO is a great one, but again, without knowing what exactly you're looking for in terms of how to analyze results, it can be a little bit deceptive. It's a good first start though. So if you're considering a new business name, by all means, go to, this website. It's very helpful. There's actually a lot of very helpful resources on it for individuals and non-attorneys. There's a series of videos, a number of FAQs that help to explain a lot of this. And so educating yourself, before, if you ultimately determine that you need a trademark attorney, educating yourself a little bit, frankly, will make your bill cheaper because you're not paying the attorney to have to explain all these things to you. So by going in and typing in your potential business name in the search and seeing what comes up, obviously, if you see something that's, a direct competitor or even closely related, probably want to be looking at something else. Obviously, internet itself, search engines, Google it, see what comes up. Looking when you're trying to, see if you can get the domain name. Maybe the domain name's taken, but oftentimes GoDaddy and many of the other registrars will offer you auto-generated suggestions for domains that are similar that are available. So, and you can, make that determination. And finally, a qualified trademark attorney is an excellent resource. And again, because, when I was talking about interpreting search results can be very nuanced and can be very difficult. It took me a long time, and I did hundreds of trademark applications for many, many clients over the years. So it's not something that you pick up easy. And I will say that some of the LegalZoom type services they may seem very attractive at the beginning because it's a very low amount of money to pay them. They are not attorneys, however. They cannot advise you on the search results. And I remember one case I got a client was very frustrated because he has used one of the services. I don't remember which one. They came back to him with a very impressive, frankly, phone book size search report and basically said, do you want us to file this application on your behalf? And he said, yes. And you don't have to be an attorney to file a trademark application, but you have to be an attorney to offer trademark legal advice. What they failed to, they couldn't advise him that there were a number of conflicts in the search, very impressive search report that they had given him. So they were leaving it up to him without telling him that he was supposed to go through these hundreds of pages and determine whether or not there was a conflict. So ultimately, he wasn't able to get his registration, and he had to come back to me, well, to any trademark attorney, but he ended up with me. And we had to start the whole process over again. So I highly recommend it. I certainly have had clients who have come to me, they've done their own registrations for years, but for the most part, it was ones that had, they usually came to me after they tried it themselves, or frankly, they had a non-trademark experienced attorney file an application for them. So definitely consider that. So I talked about the fact that you don't have a trademark until you actually sell a product or service in connection with it. So if that's the case, and that use, not registration, creates the rights, why register? And I will make a distinction. In many countries outside the US, in fact, registration and not use creates the rights. So first to file is the one that has the trademark rights. So why register? So benefits of registration for federal registration. You get to use the registration symbol, which in some studies shows that consumers respond positively to as, that this is something more official, and more of a, can be a quality indicator. We have a question. What happens if I want to trademark and I find another company with similar names to mine that aren't trademarked? So the biggest benefit of federal registration is it gives you the right to use the mark nationwide. And for the most part, for most of my former clients, that was never going to happen. They were never going to sell necessarily their product in other states or across the US, or open a chain of restaurants across the US. But what it did give them was basically an insurance policy. So by having that federal registration, even though they're not using the mark outside California or even Sacramento area, that registration prevents somebody else from coming along later, getting a registration, and then coming after them. So it provides substantial defensive benefits. But to get back to the question, so you get your registration, there's other people out there that were using it before you. You can't, and use of a mark without a registration is called common law use. You can't, and common law trademark rights exist. You can certainly proceed, in an infringement action or claim defensive trademark rights based solely on common law use. The problem with relying on common law is that you are limited only to the geographic area in which your mark was being used. So, for example, in the example that the questioner gave, they launch their business, they get their registration. Now you've got these other people that are using it. The question becomes, where were they using it? At what time the registration issued? Legally, what happens is those what are called prior junior users are frozen in their market at the time the registration issued. So the new trademark registration owner can't come back and make them cease use because they had valid common law rights prior to the registration issuing, but that prior user also can't expand beyond their geographic area. This used to be fairly easy to determine before the advent of the internet, and then it got much, much more complicated. So for example, there's a Burger King restaurant, I believe in Wisconsin, that is not affiliated with the nationwide chain. They began using the name Burger King before the chain got its federal registration. So they were entitled to continue to use the name in that market. They can't expand. So if it's still around, they can't open additional Burger King restaurants outside that, that one little, town or city that they were operating in, but they were protected in that area. So again, why go through all of that and potentially be cut off later on when you can get the federal registration and it's just peace of mind? Now I know I'm not going to have to worry about having my market constricted in the future. So it's a great benefit. It has a number of defensive benefits as well in terms of presumptions under the law as to the validity of the mark, the ownership of it, your ownership of it, the distinctiveness of the mark that can be helpful when you get into a trademark dispute. Another question, does all this apply for musician names? Yes, it can, but again, remember where it gets a little bit weird is I gave the examples of books and movies and albums where you couldn't protect the name of necessarily the title of the album until there was a second one using the same name. That would be in connection with musical recordings. And I should have addressed this previously. When we're talking about using your mark in connection with particular goods or services, the U.S. Patent and Trademark Office there's actually an international treaty that it's based off of, called the Madrid Treaty, that all goods and services are broken up into different classes. I believe there's 44 or 45 different classes. So a book is going to be in class 16. I believe a sound recording is in class 9. So to answer the question, the musician's name or the artist's name in connection with the sound recording would not be registrable until you had a second album released under the same name. However, that same name, artist name, in connection with live musical performances in class, I believe it's 42, would be registrable. Which again goes back to, I don't understand why the Patent and Trademark Office has this weird rule about movie and album titles, but regardless. So even, and that's something to consider, if you're a band and you can't get your band for the sound recording, you could certainly potentially get it for live musical performances, also for merchandise, t-shirts, things like that. So in terms of the potential conflicts, yes, you can certainly develop common law rights in your band or artist name in a particular geographic region, and then run into problems if you find out that somebody else has got a federal registration after you started using. Hopefully they got their registration after you started using it, because if they got their federal registration and you were then began using after that, this is another advantage of federal registration. The federal registration puts everyone in the country on constructive notice of your mark, so that you can't then for a claim, oh, well, I get that they got their registration, in January of 2019. I didn't know about it. So when I launched my band, in January 2020, no harm, no foul. No, you were put on constructive notice by the fact of the registration. So you have no, in fact, valid trademark rights, common law or otherwise, because your use began after the federal registration issued. So another reason to get a federal registration. Another question. I conducted a thorough search of my business name 2 years ago through the USPTO and didn't find any conflicting businesses in the US. But just a few months ago, I found a business in Illinois using my business name and in the same industry. I did some background research and learned this new business owner is a recent JD attorney claiming to be an industry disruptor of startups. Should I be concerned? My business started years before hers. No, because you've got geographical difference that, I'm assuming that your business is located here in California. You've got geographical difference. Funny enough, I did actually face this a lot in private practice with different law firms in different areas of the country using similar names, and people were getting confused because they were using those names in their domain names. So when people were searching for one firm, they ended up with another. So it can be a little bit confusing on the domain name side. But again, assuming neither of you have federal registrations, for your business name in your respective areas, Illinois and California, you are both concurrently developing common law rights in connection with your businesses in those geographic areas. So if you were to get a federal registration right now, then they would be prevented from, this other business would be prevented from expanding outside their current geographical market as of the date of registration. Great question. I'm a designer creating and selling logos. Can I trademark them and license the logo to the client instead of handing over all the rights? No, because again, go back, remember what I said, that you've got the logo. Okay, that's one element of the trademark, but the second element of the trademark is that you're actually using it in connection with the good or service. Now, you can get around that second, because you're obviously not, let's say it's an art supply store and you're not in the art supply business. You're not actually using that logo in connection with an art supply store, but you have a client who wants to do that. So you wouldn't be able to get the trademark rights in it because none have been created yet. So two ways around that. One is licensing. So you can come up with a trademark, not make any use of it, meaning you haven't sold anything in connection with it, license the use of the mark to somebody who then goes out and makes use of that in that area. So in that the earlier example, you license it to the client, and then the client goes out and makes use of it. You, at that point, would be entitled to register that mark. You can have registration based on a licensee's use and adjust the licensee's use. So you don't even have to do it. As a realistic matter, you're going to have a hard time finding a client who's going to want to agree to that. So the more, when I represented some graphic artists, they would handle it different ways. they would often retain copyrights in it, or they would go out, they'd register the copyright. We don't want to dive too much into that. That's a whole separate California Lawyers for the Arts series or presentation, which I highly recommend, by the way. But so you could potentially copyright it, but oftentimes you get into it in the agreement itself, meaning the agreement between you and your client as a graphic designer. And so I've seen it handled a number of different ways. Oftentimes the designer will retain ownership of the image, but grant an exclusive, worldwide royalty-free license, to help. They want to be able to, so for example, reserve rights to show it in their portfolio as an example of their work. And there could be other reasons that they want to do that. So there's ways as an artist to protect yourself in this space without handing over all the rights, but trademark is usually not going to be one of them.
Do I have any protection for my trademark before I begin using it in commerce?
Another great benefit of the federal system is there's an application route called an intent to use, meaning you file for the trademark. You haven't actually got any common law rights in it because you haven't used it yet. That's why it's called intent to use. So the Patent and Trademark Office is going to examine it. They're going to see if it has any conflicts. If they determine there's no conflicts with the other marks that are registered at the USPTO, then they're going to say, okay, all of the requirements for this mark have been met. Now please show us how you're using it. And at that point, you have 6 months to use it, to show use, and then you will get a registration. If you haven't done it after 6 months, another great thing about the feds, you can get up to 5 6-month extensions. So you can get up to 3 years after that, what's called a notice of allowance issues, before you actually make use of your mark. And a lot of larger companies, and even some smaller ones, do this. Let's say they're considering different product names, but they're not settling on something. Maybe they want to do some product research, some market research. And they'll say they may file 3 or 4 different trademarks on an intent to use basis because they're not sure which one they're ultimately going to go with. And then whichever one they do, then they drop the other ones that they haven't applied for. So state, it has some presumptions. It's pretty cheap. I think last time I looked, it was like $75, $80. It has some presumptions and some defensive benefits, but it is never going to trump a federal. The one reason why I would recommend, well, 2, for a client to file a state registration. One is it's quick. So the actual application process with the USPTO can take anywhere from, depending on how many issues get raised during the process. I've seen some go through as quickly as, 7 or 8 months, and some that have taken years to get. So one advantage is strategic by getting on getting that state registration going, because you'll have it's going to start showing up in trademark searches. So at least if not through the USPTO, but through any of the third-party search companies, they're also searching state databases. So by getting on there, you're going to get on their radar. That cuts both ways. So now you're on you're on everybody's radar. If you haven't already got your federal application on file, somebody else could come along, get it, and like I said, cut you off. The other instance when I would recommend it to a client is one of the requirements for federal registration is that you use your mark in interstate commerce. Now that's being as the attorneys on the call will know, that's been interpreted very broadly by the courts over the years in a number of different areas. In the trademark space, it means that you are, for example, selling your goods in multiple states, or that you're selling in one state, but visitors from other states are coming to your location and buying it. That satisfies the interstate commerce requirement as well. Frankly, that's a lot of times how my company is the basis for stuff. We may come up with a new licensed product just to test it out, and we first start selling it in our visitor center down in Fairfield. And one of the reasons why we're able to support that use for federal registration is because we can document that we've got visitors from all over the country, in fact, all over the world, coming to our location to purchase things. We don't have to show that they actually purchased that particular item. You just have to show that the particular retail location has some kind of interstate commerce to it. The other way to satisfy it, and this is more relevant in the online space, is if you are using something that affects interstate commerce to provide the good or service. And that's usually handled by the internet. So a great example is a case I had several years ago. A local beverage machine rental company advertised online. That in and of itself, isn't going to be sufficient in most cases, but they also provided the ability to reserve a machine and to buy refills online through their own website. And this was actually challenged by a very large company from out of state who had a similar name, wanted my client to stop use. We said, no, we've got rights here. We're not going to be outside the area, so go pound sand. And we actually got a court ruling on this, that in fact, my client's use was in fact sufficient for interstate commerce because of that internet connection. And so that's how a lot of times you can satisfy the interstate commerce requirement. So back to, well, what happens if you can't? And it's a really low bar. I mean, I think the USPTO has found that even, the sale of like one hat in one state to an out-of-state visitor was sufficient. But if you really can't do it, and in my practice, the only industry I really found that it could be potentially difficult to show any effect in interstate commerce was charter schools, when they were only, obviously you're offering those educational services in a very limited geographic area. If their websites weren't sophisticated, meaning that the students couldn't, for example, register for classes via the website, that would be an effect on interstate commerce that would support interstate use. Other kinds of functionality. If the websites were purely informational and, for example, directed you to, call a telephone number to get more information and to register your child, that would probably be purely intrastate use and wouldn't support federal registration. Bottom line, I would always recommend a federal registration if you can possibly get it, because you have so many more rights. Let's see, we have some other questions that have come in. Can you trademark the name of a podcast? Would that fall into a sound recording class? Absolutely. There's actually a couple of different classes, I think, that cover podcasts. So that's certainly something that is federally registrable. Another question, for a comic series of multiple issues, does the second issue need to be published before seeking trademark registration? No, if you went the intent to use route. Yes, if you were going to go traditional. So, again, that's one of the advantages of the intent to use. You're prepping the second issue. You want to make this happen as quickly as possible. The great thing about the intent to use is, let's say, you file in June of 2020, you don't get your registration until, say, March of 2021. Even though you didn't make use until then, until March of next year, the PTO grants you a constructive use date as of your filing date. So it was as if you had made use of your mark the day that you filed it. So that can be very important. Second part of the question, does digital sales count as publication? It absolutely can. The publication method isn't as important as that there be that second distribution, or the distribution of that second title. Do we have to apply separately for federal and state? Yes, you would apply for a state registration with the California Secretary of State and a federal registration separately through the U.S. Patent and Trademark Office. So what do you do while your application is pending, especially for federal? You can place, and you've probably seen this on a lot of stuff, the TM symbol after a trademark or a slogan, SM for service mark. The distinction really doesn't matter legally. The point is, by using these symbols, you are telling the world that you are claiming common law trademark rights in these things. So it can help to defeat a claim of innocent infringement later on. Once the mark is registered, you want to replace the TM or SM with one of the three examples here. Most commonly, people use the circle R because people recognize it and it doesn't take up much real estate on the packaging or the advertising. How much does it cost to register a trademark? Is it a one-time fee or yearly fee? So maintaining registration. So you have a filing fee initially with your initial application, and then there are no more fees associated until you renew it. You have to renew between the 5th and 6th year, and then again between the 9th and 10th year, and then it's every 10 years after that. The amount you pay determines how many classes the registration covers. So if it's only in connection with, one class with, let's say, with the artist example, and it's sound recordings in one class. But if you have the band name also registered in connection with live performances in another class, with apparel in another class, potentially some other, licensed stuff, all of the fees are determined by the number of classes. And the state is every 5 years. Does my band need to file nationwide to prevent uses with other bands? Ideally, yes. You want to make sure you're using in interstate commerce. That's usually pretty easy to do, especially as a band. If you are, you have your own band website and you're distributing, downloadable samples or maybe streaming a couple of your songs, that would satisfy that. So that would be a good thing to do. So what not to do with your trademark? Never use it in the plural unless it's in fact plural. Never use it in the possessive. And all of these go to altering your mark in some way. The use in the possessive also makes it more potentially like a verb. Now you're getting into potential genericism issues when you're not using your mark as a trademark. You don't want to abbreviate it, and don't want to use it in connection with goods or services not covered by the application. Those first four really deal with the fact that once you apply for your mark, it's very difficult to make alterations to it and be able to continue to have it exist under the same registration. The Patent and Trademark Office defines it as a material alteration, but they will find what I used to consider very small differences to be material. I had a client, we applied for the mark as a 2-word mark, got the registration. Their use changed a little bit over the years, and when we went to time to register, to renew it, they had moved the 2 words closer together. I thought they were still 2 different words. The USPTO disagreed with me and my client. And so we had to appeal and amend the registration to a 1-word registration. So again, another good reason to have a trademark attorney throughout this process, because you get your registration, 5 years go by, you're probably not going to hear from your attorney. In that time, having somebody to be able to contact and say, hey, we're thinking about making this change to the mark. We want to change our branding. We want to do this. Is this going to be covered by our registration? And so that can be, and it can be like the example I gave, a very, very fine line. Use the mark with, and obviously don't use it with goods or services not covered by your application, because although you may have it in one class, somebody else may have it in another. If you move into that class, now you could be potentially infringing. And the last one goes to abandonment. And this goes back to the earlier question about, can I use a mark that hasn't been, it's no longer registered? So abandonment occurs when you cease offering the goods or services in connection with the mark. If it's only temporary, that can be what's called excusable non-use. So I had a client that was a beer company. They had a federal registration. They were leasing a production facility. That lease fell apart. So at the time they needed to renew, they weren't actually producing beer, but they were actively searching for and could demonstrate to the USPTO, no, we expect to resume production in 3 months. We've got this, we're just finalizing this deal. And that was called excusable non-use. So you can have temporary pauses in the use of your mark, but if it's something else, I had another client, they had a restaurant on a train car, those services ceased. They were actively looking to replace, the car to be able to do those services, but they hadn't done it yet, and they didn't have anything concrete. So the PTO said, sorry, that's not excusable. You haven't given us anything specific to show us that you're going to be, reusing this mark in connection with these services in a reasonable period of time. And so, unfortunately, the registration was canceled. So when can you use somebody else's trademark? The first is called fair use, and the legal term is nominative. And when you're using another person's mark to refer to that person's product or service for the purpose of comparison or identification. So a classic example is comparative advertising. So I'm not sure if this image comes from Coke or from Pepsi or who did it originally, but you're entitled to use somebody else's trademark when you're referring to their product or service. The new kids are there because it was a very classic case. A newspaper had conducted it was a poll, and some of the questions revolved the band New Kids on the Block, and New Kids sued saying you used our trademark without our permission, and said, well, no, we were referring to you as the band. We weren't trying to trade off of you or anything. We have to refer to you if we are referring to you. We have to use your trademark. And so those uses are acceptable. Another fair use is when you're not using somebody else's trademark as a trademark. You're using it in its ordinary descriptive meaning to describe a good or service. So Sweet Tart. Sweet Tart is in fact a registered trademark for the Sweet Tart brand of candy. However, when you're using it to describe a juice flavor in your product that is, my cran apple juice is Sweet Tart, you're using it descriptively and not as a trademark. Fish fry is another one. Fish fry is actually a registered trademark, but if you're just using it like here to describe a batter coating for fish, that's a fair descriptive use. One thing to really look for is making sure that you're not making, the use that how you're using the mark it's appearing in text, in the same font, in the same size as everything else. You're not capitalizing it. You're not trying to call any attention to that term other than that it's pure descriptive English meaning. So how else can you use a mark? And this is a much more complicated area. I don't recommend diving into this without legal advice. Parody versus satire. So parody is when you're using another's mark that comments on or criticizes the underlying mark of the mark owner. A very famous case was Chewy Vuitton versus Louis Vuitton. So on the right, or on the left rather, there's this chew toy for dogs, obviously playing off of the Louis Vuitton name, and some of the symbols are very similar. And it's again, you know, where the line is in funny and appropriate as a parody and where it goes into trademark blurring or tarnishment can be very, very difficult to determine. But in this case, Louis Vuitton succeeded on its parody defense. Satire is a little different, and you see this more. I think this is where, in some cases, you're using somebody else's trademark and it's targeting a third party. You're not commenting on the actual mark owner, like Louis Vuitton was commenting on Louis Vuitton. And a good example is the Cat in the Hat versus the Cat Not in the Hat. The Cat Not in the Hat was I'm sure the authors thought, very entertaining, funny look at the retelling of the O.J. Simpson trial in the style of Dr. Seuss. And however funny it may have been, the book wasn't making any comment on Dr. Seuss or the original Cat in the Hat. They were just using those images and that style to make another point, and that's satire. And from the legal realm and all of this, the importance is that parody receives much greater protection than satire. So just because your client, if you're an attorney out there, coming up with you think maybe a hilarious use of somebody else's trademark, if you're not really confident they're really poking fun at the trademark owner as opposed to some third party, it's probably not going to be an effective defense. And even if it is an effective parody defense, you're probably going up against large companies with a lot of resources that even if you ultimately, win the day with your parody defense, your client has probably spent a great deal of money to get there. So getting into the art realm, using another's trademark in expressive works. And the test is whether the risk of confusion is outweighed by the interest in artistic expression, specifically the First Amendment. So 2 examples: an artist used paintings of University of Alabama football players. The University of Alabama sued for use of the trademark, and the court said, no, this is an expressive First Amendment use. Similarly, an artist created a collage of Tiger Woods images. Tiger Woods went after them, and they said, well, no, this is an expressive use, not a trademark use. But again, these lines can be very blurry, very nuanced, and so it can be very difficult to advise clients on. Had a couple of other questions come in. For video and sound recordings, is it sufficient to establish use by just putting them on your webpage, even though you're not charging for them? Excellent question. Yes, as with free podcasts, you don't have to be necessarily charging money in order to establish use. It just depends on the specific area. So for blogs, for video and sound recordings that can be distributed, but basically anything that can be distributed by the internet, even if you're distributing it for free, you're still qualifying for use. And again, blogs are another excellent example of that. This is an example I want to give. This goes back to related to the earlier question about if a graphic designer creates a logo, is it owned by the designer or the business that hired the designer? Let me answer that first. It's going to be governed by the agreement itself, which is what always want to have written agreements if you're a graphic designer with your clients. And it protects both the designer and the client. If it's potentially copyrightable, you as the creator of the logo are assumed to be the copyright owner unless that interest is transferred separately, and which is why I talked about in a lot of cases, graphic designers will retain copyright ownership in the image, but grant a very, very, very broad license for the customer to use it. So that protects on the graphic designer side. This slide is an example of how you want to have an agreement if you're hiring a graphic designer for something that can come up, and in fact did come up for one of my clients. This is a actual language from a clip art license site. And I won't go through the whole thing, you can see it. But the point is that this is limiting the use of the images on the site for personal use, not commercial use. So if you're a graphic designer and you are getting clip art images from different sites, or from a collection that you may have that you purchased at some point, you want to read these licenses very carefully. I know we all don't. We just scroll through and click, I agree. But in this case, I had a client and the graphic designer used an image from a site that was restricted to personal use only, and using an image as a graphic designer in the process of designing a logo or whatever you're designing for your client is definitely a commercial use. And the image owner actually went after my client, not the artist. We obviously tried to go back to the graphic artist and say, hey, you owe us, for these defense costs. And they said, yeah, right, I have no money. So it was up to my client, have to pay those costs, and ended up having to change the logo. So these are the agreements between graphic artists and their clients are very important for both sides. So let's end this on a happier note where you can use somebody else's trademark in your artwork. And this is called the Wheel of Everyday Life. Forgive me, I don't recall where this installation is, but as we get closer, if you look carefully, you can see that the artist has incorporated logos from a number of different famous brands very creatively, I think very beautifully. You can see Shell Oil, Tasty Cake, Kmart, Craftsman Tools, The Today Show, organized and arranged in such a way that is both very beautiful and very permissible under the First Amendment as an expressive use of someone else's trademark in an artistic work. In the trademark application, the examining attorney might view my mark as descriptive and maybe reject it, but I believe I may be able to register it as supplemental. Can I request it to be supplemental rather than descriptive in the initial application? This is a great question. I didn't really dive into this because we're getting down into the weeds a little bit, but there are two registers when you're registering with the federal USPTO. The principal register, which is what most people do, that's where you get all of the presumptions. But if, as in this case, the PTO has determined that your mark is descriptive, you can register it on the supplemental register. You still get to use the registration symbol, the R in a circle, but you don't. It's a weaker registration. It doesn't have all of the presumptions. It's still very worthwhile. And as to the specific question, I wouldn't recommend applying initially to the supplemental because you can always amend back to it. So you apply under the principal, examining attorney says, no, this is descriptive, but will allow you to amend to the supplemental. So I would definitely do that. Can you trademark logos with fonts? Yes. I didn't get into this either, but you've got two options when you're, well, basically two. If you're applying for a word mark, you can apply for it in plain words. So Acme, just block letters, ACME. And the advantage of the plain word mark registration is that it protects that use of that word Acme, regardless of how it's displayed. You could have capital A, small CME. You could have a cursive font. You could have whatever font you want. And so your mark is that word is going to be protected regardless of how it's displayed. The second option is what's called a design mark application. And that's when the words may be stylized. So Acme in a particular font. Acme, there may be some design elements incorporated around the word Acme. And so that will help you to protect that specific word in that font. That doesn't mean that somebody else can't use that font unless it is too similar to your mark and to your goods and services. The disadvantage of the design application is that when I talked about material alteration earlier, that your mark has to be almost exactly the same, your registration is only going to cover that design mark as it appears. So if later on down the road, or if you're an attorney, your client wants to change the font, wants to change it to all caps, something else, you're covered on the plain word mark registration, but under design mark, you'd be looking at having to do a new registration because there is very little alteration that's permitted for design marks. Can I apply DBA doing business as one class, but add more later on? Yes, but in separate applications. So you're going to be doing a new application every time. You can apply multi-class at the beginning, but once you apply, except in very limited circumstances, you can't add classes. How broad is the trademark as art exception? Again, a very good question, but volumes of treatises have been written on the issue, and it's very fact specific. So it's going to come down to the individual artist's use of the particular mark in the art. And so, like with a lot of what I've been talking about today, it's a case-by-case basis, and definitely would want expert trademark attorney advice on that.
What is your favorite Jelly Belly flavor?
I have three depending on my mood. I like licorice. I know that's controversial. I'm sorry for those of you who are not licorice fans out there. Also pomegranate, and my third would be chili mango.